On May 2, 2025, Michigan driver Ron Doyle Glenn faced a series of traffic-related charges, 8 in total, including 5 civil infractions and 3 misdemeanor offenses under Michigan law. Individuals charged with civil infractions can typically resolve their cases by either paying a fine or requesting a hearing. However, those facing criminal charges, even misdemeanors, are required to appear in court for a formal arraignment. Mr. Glenn's arraignment for the misdemeanor charges, along with a hearing for the civil infractions, was scheduled for June 6, 2025, but when the date arrived, he failed to appear. As a result, default judgments were entered against him for the civil infractions, which is permitted under Michigan law. However, since default judgments cannot be entered for criminal charges, the court instead scheduled a show cause hearing for August 19, 2025. In compliance with Michigan Court Rule 6.615, a show cause hearing is a proceeding that occurs after a missed court date or other violation of a court order. During this hearing, the defendant must appear and explain why they failed to appear and why they shouldn't be held in contempt or face additional penalties. Meanwhile, on May 21, 2025, Mr. Glenn was cited again, this time with 4 additional traffic violations, 1 civil infraction, and 3 misdemeanors, including driving with a suspended license. His arraignment for these new misdemeanor offenses was scheduled for July 3, 2025. But once again, Mr. Glenn did not show up. The court then scheduled another show cause hearing for July 28, 2025. In addition, a separate hearing for the new civil infraction was set for July 7, 2025, but Mr. Glenn failed to appear yet again, leading to another default judgment. Finally, on July 28, 2025, Judge Sha Perkins presided over the first scheduled show cause hearing in the virtual courtroom of Michigan's 36th District Court in Detroit. Mr. Glenn appeared via Zoom, represented by attorney Phyllis Gahan Robinson.
Are you driving, sir? Mr. Glenn, Ron Doyle Glenn?
Yeah, man, I'm sitting out in the sun, buddy. I'm trying to grab me something to eat.
All right, don't drive in court.
I'm not going to be driving, buddy, when I'm in court, all right? Just call me.
No, listen, I'm not your buddy, okay? First of all, but at the end of the day, if you're driving right now, you're not supposed to be driving, okay?
Yeah, but how long am I going to be sitting here? I haven't spoke to no defense attorney.
I don't know how long you're going to be sitting there. You're waiting. If you came on time, you would have heard me. I said I'm going to try to get you out as fast as I can.
It's all good, man. Listen, it's all good.
Listen, don't cut me off. Are you driving your car right now?
I'm going to park my car, but, man, I can't be sitting out in the sun.
I'm putting you out of the room.
Put me out of the room?
Yes, for driving in court. All right? Come back when you get in a safe location.
Attorney Gahan Robinson on behalf of Mr. Ron Doyle Glenn. Mr. Glenn, please state your name for the record.
Mr. Ron Doyle Glenn.
Your Honor, I don't know how many tickets that was you just read off. I only have 3 on my docket.
Yeah, Mr. Glenn doesn't have any respect for the court. I see he's exhibited disrespect to the court, and he's
wait a minute, hold on, wait a minute. What you talking about?
You wait a minute. You wait a minute.
I'm going to the Judicial Technical Commission.
You wait a minute.
I don't want you to remove yourself from my case, bro.
Listen,
I'm 58 years old.
That's the disrespect.
I don't know what it is about me and you, bro.
That's the disrespect.
Mr. Glenn, can you please be quiet for one? Mr. Glenn, as the attorney who's trying to help you, can you please be quiet for a moment? The first issue that you have is you should not be driving on Zoom. Park the car, please. You cannot drive on Zoom. This is the definition of distracted driving.
He should not be driving at all. He's already indicated to the court that he's driving when he was driving while in court. I asked Mr. Glenn that he's driving. He said he's driving to go in to get something to eat, I believe. So now
Mr. Glenn wasn't driving. Somebody was driving for me. I'm with somebody. What do you mean? What do you mean, man?
I'm
I'm 58 years old, bro.
Mr. Glenn, I'm trying to help you. Can you please just wait a minute?
All these tickets from 20 years ago when it's only 3. You know what I'm saying?
Sir, stop. Mr. Glenn, stop so I can help you. I'm trying my very best to help you. You got a chip on your shoulder, but it's not. Sir, give me a minute. I'm gonna try to take you in a breakout room and talk to you before you make your circumstance worse. Just be quiet until you get there, please.
Yeah. Okay.
Thank
Mr.
you.
Glenn, Mr. Glenn, after you finish talking to him, I'm gonna give him a pre-trial date for tomorrow. Mr. Glenn has to come into court in person.
Fine. I'm going to the Judicial Tender Commission because you're very impartial. You're not about to try to embarrass me in court like that, man.
Mr. Glenn, stop.
Reading out all
Mr.
those statements
Glenn,
when we only got
I
3.
just asked you to be quiet so I can help you.
I'm going to file a complaint today.
That's fine. You can do whatever you want, but
You're not about to try to embarrass me like that and be disrespectful to me and think I'm gonna sit up and take that.
Mr. Glenn, Mr. Glenn.
And he come to court properly dressed. Don't come to court in a sleeveless shirt. Come to court properly dressed.
Your Honor, can I please have a moment to talk to Mr. Glenn? I muted you because you're not making it better. Just be quiet.
It doesn't matter what you say to him. He's gonna take an anger management class too.
Your Honor, I'm gonna move Mr. Glenn to another breakout room.
Very good.
He's the Motorola device.
Yes. Move past the matter. Tell him to come to court properly dressed, Ms. Gates.
Mr. Glenn, you should have a prompt to go to breakout room 5. Go to breakout room 5. Look at your device, Mr. Glenn. You should have a prompt on your screen to go to breakout room 5. Just click OK. All right, Mr. Glenn, I'm gonna send you a different prompt. Just when you see the room number pop up, please just click OK. You're going to room 8.
All right, let's pass.
Just click OK.
Ms. Gaten Robinson, are you still dealing with Mr. Glenn?
Your Honor, Mr. Glenn was not the easiest to try to talk to or get to reason with. He has indicated to me, is he still in the breakout room? He told me he was coming down to the court today. He doesn't understand why he has to come tomorrow, so he's coming down to talk to the chief judge today, which I told him that is absolutely his right. He could. He felt like you were picking on him by calling out his older tickets. I explained to him that that is your process and the process of many judges down there, that when people have outstanding matters, if they are on your docket, you will pull all of their matters in an attempt to be efficient. And you've done that with multiple clients of mine this morning to try to reassure him that that was not you picking on him. He didn't understand why you were bringing up old stuff. So I explained to him that that's you trying to be efficient because he had multiple tickets in front of the court outside of the 3 that were on the docket.
Attorney Phyllis Gayen Robinson informed Judge Sha Perkins that her client, Mr. Ron Doyle Glenn, had become offended when the judge called both the May 2, 2025 misdemeanor charges and the 3 additional misdemeanor charges currently listed on the docket. Ms. Robinson explained to the court that she had spoken with Mr. Glenn and clarified the reasoning behind the judge's decision. She noted that Judge Perkins was not singling out Mr. Glenn, but rather acting in the interest of judicial economy, a legal principle focused on the efficient use of court resources to ensure that cases are handled promptly, effectively, and without unnecessary duplication of effort. In this situation, because Mr. Glenn already had another show cause hearing scheduled for the following month, Judge Perkins chose to address all of his pending charges at once. This approach was intended to streamline the process and avoid the need for multiple, repetitive hearings, thereby promoting a more efficient resolution of all matters before the court.
I indicated to him that he was supposed to be here tomorrow at 8:30 in the morning.
He's here.
I got his attention. He's aware that we're trying to pull him back into the breakout room. I'm about to send him a prompt. To the main session. I'm about to send him a prompt.
I'm trying to get him in the main. I close the rooms.
Okay.
Now, if he keeps it up, he'll find himself in contempt.
Your Honor, I'm trying to save him, but.
And I know it's probably going to be ordered as a transcript. So can y'all please talk at one time at a time?
Well, good luck. Good luck. You can get the video.
Sure.
All right. Let's go back on the record with Mr. Glenn. Mr. Glenn, let me say something to you, sir. Start your video, please.
I got it going. Get it straight now. Get it straight, bro. I simply wanted to come in and plead not guilty.
So, Mr. Glenn,
Stop
I
it right
asked you to
now.
stop talking to the judge like he's your friend or somebody on the street. You would not talk to another judge in a different jurisdiction like that. He's not
How you
your
know that?
bro. He's Judge Perkins.
Now, let me stop. Let me stop right
I'm
there.
trying
Let
to
me
help you,
stop.
Mr. Glenn. You
Man,
making
no,
it worse.
stop, Miss Gayden Robinson, please. Mr. Glenn, let's get this understanding. First of all, I'm not your bro, okay? Yeah, I'm the judge, Mr. Perkins, but I'm not your bro, okay?
I know
Secondly,
you're not. Yeah.
no, I didn't ask you to speak. Don't talk while I'm talking. Secondly, if you continue to act out like you've been doing, I'm gonna have no choice but to hold you in contempt of court, okay? And I don't want to do that. I'm trying to exercise the utmost restraint with you.
During the hearing, Judge Sha Perkins firmly reprimanded Mr. Ron Doyle Glenn after he repeatedly interrupted the court and referred to the judge as bro. Judge Perkins warned Mr. Glenn that if he continued to behave in this manner, he could be held in contempt of court. Under Section 600.1701 of the Michigan compiled laws, judges are granted the authority to punish individuals for contempt of court when they engage in misconduct during judicial proceedings. This includes any disorderly, disrespectful, or insolent behavior that disrupts the proceedings or undermines the dignity and authority of the court. Using a casual or colloquial term like bro to address a judge can be interpreted as a willful sign of disrespect, especially within the formal setting of a courtroom. Similarly, interrupting the judge or talking over others during a hearing disrupts the orderly flow of the proceeding and can be viewed as a direct interference with the court's process. Given these circumstances, Judge Perkins' warning was justified, as Mr. Glenn's actions could reasonably have been considered grounds for a finding of contempt of court under Michigan law.